This all started really in 2011. It probably preceded 2011, but 2011 was when USDA and APHIS first started announced that they were going to be pursuing and with the eventual idea of adopting a rule or regulation about animal traceability and identification. So it gives you an idea of how the folks that we're dealing with, whether in the agencies or some of the organizations that Tracy described today, they always play the long game. 10 years to them is a blink of the eye. And so what you know is that when we fight these battles and when you get into these battles, you don't get into a battle and win and think you can go on about your business and move on to the next thing, because that isn't the way that they look at it. Everything that they do has a purpose, and everything that they do has an end goal that they will ultimately prevail. And it's why it was so important that RCAF was willing to get involved in this fight. Again, and I'll explain more about that in a little bit. The 2011 effort actually ended up resulting in what we refer to as the 2013 final rule. And the 2013 final rule, I know that Kenny was involved with that, and I believe that Tracy may have been as well. But the idea at that point was USDA and APHIS were going to force RFID technology on all of you at that point. But there was sufficient pushback that they did not have the political capital to do it. So instead, the 2013 final rule actually recognizes all different kinds of identification, whether it's brands or back tags, tattoos, ear tags, and that sort of thing. And that was a good thing, because what it did is it put into law, it actually created a regulation whereby states are required to recognize a variety of different technologies and techniques for animal traceability and identification. Actually, one of the few rules that I've ever seen that protected the industry that it was attempting to protect, which is you guys. So if you use brands or regular, the bangs tags, or you use the tattoos, you can continue to do that. But even though, and at that time, RFID was specifically rejected. In other words, they actually wrote in the rule that states and tribes cannot mandate RFID ear tags against livestock producers. Again, that was a huge win for you guys. But I am going to tell you that the USDA, APHIS, and the ear tag manufacturing companies and the other interests that have been focusing on this, they have never given up. And so immediately after the 2013 rule went into effect, they got together with a group of people, created the Cattle Traceability Working Group in 2017, of which Kenny Fox was a member, and continued to discuss the idea of adopting RFID or mandatory RFID technology. There were people in that group who refused to knuckle under and continued to fight against our mandatory RFID. According to the USDA, the cost about 10 years ago for mandatory RFID would be between $1.2 and $1.9 billion. I would expect that it has more than doubled in cost since then, and they also recognized that that would all be footed by the livestock industry. So it was something that was never going to be a good thing for you. It's never going to be a good thing for the cattle producers. It actually provides very little benefit to you, but for the packers, the ear tag manufacturing companies, and the globalists, it's a great idea. So in 2017, USDA and APHIS moved forward with trying to get an advisory committee to recommend RFID. And because of people like Kenny Fox, they fought back against it. So ultimately, they got rid of all of the naysayers, got rid of anybody who opposed it, and created a second group called the PTC, the Producers Traceability Council. And that organization actually was all pro-RFID, and they recommended going forward. In April of 2019, there was a funny little document that showed up on the website for the USDA. It was just a little 2-page document. Very little detail, very little text, but Tracy Hunt knew that I had taken a position with a nonprofit law firm out of Washington, D.C. I live in Wyoming, but I work out of Washington, D.C., so some days it's a fairly long commute. But he called me and he said, I found this document on the USDA website. Do you know anything about it? And I looked at it and I said, I really don't know anything about it, but started doing some research and realized immediately that it violated the 2013 regulation. So Tracy got a hold of some of the other folks, including Bill Bullard, and we eventually moved forward with filing a lawsuit challenging the adoption of what was then called it was a fact sheet, and it was a mandatory RFID requirement for all livestock producers if you were going to move your cattle interstate. It was mandatory that as of January 1st, 2023, every one of you would be required to have RFID ear tags on your cattle, and bison and a few other types of livestock as well. It was illegal as hell, and so we filed a lawsuit on October 4th, and by October 25th, USDA withdrew that fact sheet. And so we won, which, as Tracy said, never happens. But it gives you an idea of how strong our case was in that. But also, as I've thought a lot about this, because the USDA, EPA, U.S. Fish and Wildlife Service, Forest Service, I can give you all different kinds of federal agencies. They don't necessarily care if what they do is legal. They care if they can get away with it. And so the fact that they withdrew this and withdrew it as quickly as they did obviously raised some pretty serious red flags for me, because what I realized is they did not want any kind of scrutiny on what they were doing at that time. And that is actually my skepticism as to what they did has been borne out since then. So they withdrew the fact sheet and immediately called me. The U.S. attorney called me and said, we need you to dismiss this lawsuit. We withdrew the fact sheet. And I said, I'm not going to withdraw that lawsuit. I'm not going to dismiss it. I said, I want you to file a motion to dismiss because I want a decision from the court saying that what you did was illegal. And we fought over that for a couple of months. They finally filed their motion to dismiss. We responded to it, and in February of 2020, the district court, in fact, did rule that our case was moot and dismissed our lawsuit. But at the same time, she issued a very good decision essentially saying that for the USDA to move forward with an RFID mandate, they would have to go through the regular rulemaking process. That's the thing they're trying to avoid. They know if they have to go through a rulemaking, the producers themselves are going to come out of the woodwork and fight hard against it, which is what happened in 2011 and 2013. So this was an effort to fly under the radar, violate the law, and hope that they could force all of you into this mandatory RFID without following the rules. But one of the things that she did not do, or she didn't address in her decision, was the fact that we had sued them for violating the Federal Advisory Committee Act. Because by creating the CTWG and the PTC, they never followed the law. What they did is they got this group of people together in a room and they said, we need you to try to go forward and push forward with RFID, but we're not going to follow the law. And under the Federal Advisory Committee Act, if a federal agency puts together an advisory committee, they have all kinds of regulations they have to follow. I mean, come on, it's the federal government. Of course they're going to have to follow all kinds of bureaucratic stuff to be able to get anything done. Well, they didn't follow any of those rules when they put these two committees together. So we asked to be able to amend our complaint and focus specifically on that issue, and the district court judge allowed us to do that. So as of last April of 2020, we filed an amended complaint focusing specifically on these advisory committees. And the reason it was important to do that is because to the extent they violated FACA, or the Federal Advisory Committee Act, all of the work product from those groups can never be used again. It's the fruit of the poisonous tree. So all of the materials, all of the reports, all of the data, all of the money that has gone into pushing forward with RFID for the last 10 years is moot. They can't rely on it. So a lot of people don't understand what FACA is or what FACA does, but it can be an incredibly powerful tool to stop an agency from being able to violate the law and then come in and say, well, no harm, no foul. We've got a really good report here about why RFID is so good. So we filed that lawsuit in April, and after that, the feds, the USDA and APHIS, they filed their administrative record. But at the same time we filed that lawsuit, we filed a FOIA. We did a Freedom of Information Act request, which is a different tactic and a different track than our lawsuit. So they came out in July of last year. They threw a few documents on the table and said, well, this is the entire administrative record related to the work that we did for the RFID and for these groups. Well, we knew that that was hogwash. That's why we had done the FOIA request. But again, because it's the federal government, they don't necessarily talk to each other, even if they're in the same agency. So USD has one segment of its agency that deals with FOIAs, Freedom of Information Act requests, and then they have a separate part of the agency that deals with lawsuits. So on this side, where they're defending against our case, they gave us a few documents and said, this is it, there's nothing to see here, move on. The FOIA people didn't realize, though, that that was the approach that they were taking. So they were giving us documents on this side that absolutely confirmed the illegality of these advisory committees. So we went back, we disclosed this to the court, we went back to the court, and in fact, they had to supplement the administrative record. So the other thing that we were trying to do, however, is we were also trying to do discovery, because I really want to get some of these people under oath. I would love to have the opportunity to sit down and talk to some of these administrators in USDA and APHIS and ask them questions about their involvement with ear tag manufacturing companies, with NCBA, with the beef checkoff, with the Packers, with all of these folks, and what was going on behind the scenes and what kind of money was involved in that sort of thing. Well, again, that is absolutely the last thing that these people want to do. So they have fought very hard against allowing us to do discovery, and that's a battle that we continue to fight. So we were able to, we've been successful in getting the administrative record supplemented a couple of different times with some very important documents. And then earlier this year, we went through the briefing process where we actually briefed the substance of whether they violated the Federal Advisory Committee Act. And as of just in May, actually, as of May, the judge ruled against us. And she said, you didn't prove that they created these advisory committees. And my response was, well, you really didn't allow us to prove that they created these advisory committees because you refused to allow us to do discovery. So in May, she ruled against us, but again, I think that in some ways it was a win because we continue to expose them and expose all of their tactics and their activities to the light of day. But again, we're not done. We are not done fighting this. So we filed an appeal to the 10th Circuit Court of Appeals, and our brief is due on Tuesday. So I've been back there. A lot of the typing I've been doing and working on is we're working on our appendix. We're working on finalizing our brief right now. We will be filing all of this on your behalf on Tuesday. I think we have some really phenomenal arguments that we are making against the federal government and how they handled this, what they did, and why. Number one, we should be able to do discovery, but number two, why they violated FACA, and then we are seeking an injunction. So again, all of the work product related to those two advisory committees will be thrown out. So anything that is dated prior to today's date or whenever we get that decision, it will not be able to be used as they pursue RFID into the future. If we're successful at that, it will put them back years potentially in being able to push forward with an RFID mandate. One other thing we were able to do is during the middle of all of this, because we had stopped them once, last July they issued yet another guidance document. This time they did publish it in the Federal Register, and what they said is, we're going to go forward with mandatory RFID by January 1, 2023. We jumped in the middle of them as fast and as hard as we could, and as of January this year, they withdrew that. So again, they tried yet again to do it informally without following the law, without following the proper procedure. We have been able to push back, but they did announce earlier this year that they are going forward with a formal rulemaking in order to impose RFID. As someone who deals with rulemakings all the time, I can assure you that they typically take several years to complete. And right now, this administration is in such complete and total disarray that I am not sure that that is going to be one of the priorities that USDA is looking at for a lot of other reasons. So we'll see if and when they come out with a draft or proposed rule. But so far, because of RCAF, because of our individual clients, we have been able to stop them from pursuing what I believe is a very insidious form of surveillance and the first step in completely federalizing your operations. So again, thank you to RCAF, thank you to my individual clients for being willing to fight this fight. It is an important one for a lot of other reasons, and again, I'll explain why that is with some of the other work that RCAF is doing. So again, right now where we stand is that we are getting prepared to file our 10th Circuit Court brief on your behalf next week. The feds will have 30 days to respond. We will have another 15 days to do our reply. I'm anticipating we will be doing oral argument before the 10th Circuit in November or December of this year, maybe January. I'm looking forward to continuing to fight this battle and to pushing back against these federal agencies. There are some other things I'd like to tell you about NCLA that we have been working on for the last year especially. This has been the wildest year I have ever seen in my entire legal career. I have been doing this for over 32 years. Throughout that time, I have been a civil rights attorney. I'm primarily a water and natural resource attorney, but what that means is I protect property rights, I fight on First Amendment issues, I've dealt with freedom of religion, but probably what I'm best known for is protecting property rights, because I truly believe, and I think I said this last year, if you can't own property, you are property. So watching what has happened to our government, our federal government, our states, and our courts over the last year has been really something that I don't think that I ever expected, and I'm sure that most of you never expected to see either. So as a result, NCLA has had to somewhat change what our mission has been, at least for the last year, in terms of really focusing on what we see as government overreach. We have sued the governor of Massachusetts. He issued 160 different executive orders. We sued him. We're heading up to the United States Supreme Court on that case. We have filed a cert petition. We immediately went to the Supreme Court. That case was one of the first ones that went up in being heard by a state or the United States Supreme Court. We lost at the Supreme Court level in Massachusetts. Every one of whom were appointed by that particular governor, so we recognized that that was a risk, but we had to sue him because the level of constitutional overreach that guy engaged in was just absolutely stunning. But what was even more stunning was attending the hearing and having justices say, yeah, Constitution, yeah, we kind of get that, but don't you think he's doing a pretty good job? No? No, I'll raise my hand on that one and say he isn't. Anytime you're violating constitutional rights, you're not doing a good job. So we're taking that one up, as I said, to the U.S. Supreme Court. We also sued the governor of New Jersey, the gentleman who went on Tucker Carlson very early in all of this, and when asked about the Constitution said, Constitution? That's above my pay grade. When describing his unconstitutional overreach. We've sued him. We also sued the federal government, the CDC, over their eviction moratorium. We believe that absolutely was one of the most heinous examples of unconstitutional takings that we've ever seen, and clearly outside of the authority of the CDC. We are hoping to get that before the United States Supreme Court as well. Again, maybe Kavanaugh this time will have the guts to do the right thing. But we are before the 11th Circuit Court of Appeals right now on the CDC eviction moratorium. One of the other important cases this year from my standpoint was I represented a property rights owner west of Cheyenne, Wyoming, that the county commissioners had decided that how he was using his property really was not the vision that they had in mind for that 500 acres. And so I ultimately took that to the Wyoming Supreme Court because their vision really didn't comport with his property rights. And we received a really, really good decision out of the Wyoming Supreme Court, further confirming and protecting property rights in the state of Wyoming and pushing back against counties and cities who want to restrict what people can do with their private property without going through a proper zoning change or modification. So that was an incredibly important case, and then we were ultimately successful in getting 3 statutory changes in Wyoming, further codifying that decision. So it is going to be much more difficult for the bureaucrats to try to restrict what you can do in Wyoming with your property. So that was huge. The other thing that we have been doing most recently, and that is we are attempting to stop or at least throw a wrench in what has been going on across the country with mandatory vaccinations. And again, I don't think I could have told you a year ago that I would be talking about my country mandating experimental vaccines against anyone over 12 years old, but that's where we are today. And the most recent lawsuit we filed was against George Mason University. We're doing this incrementally. You have to do this on a stepwise approach, and the way that we are doing it with this particular issue is we all know that there's probably close to 100 million people who have natural immunities. And most of these government and private entities are not making any allowances for people who have natural immunities. They are dividing people into vaccinated and unvaccinated, which is absolutely contrary to any scientific construct you would have in terms of looking at viruses and how they work. So they are refusing to acknowledge natural immunity as one of the reasons why people should not have to be vaccinated. So we sued GMU, I want to say 2 or 3 weeks ago, George Mason University, on behalf of a professor. His name's Professor Zawecki. You may have seen him on TV several times over the last couple of weeks with Tucker Carlson and Laura Ingraham and different ones talking about this. He has very robust natural immunities, and he teaches at the law school at GMU. They were going to force him to be vaccinated. We were successful in getting them to back down, and they have given him an exemption. They've said it is a medical exemption. They won't acknowledge that it has to do with his natural immunities, but they never would have granted it had we not filed that lawsuit. So right now we're in the process of doing that with others as well. We've got probably, I don't know, maybe 500 or 600 emails that I've received in the last 10 days from people all over the United States, absolutely panicked about having to get a vaccine that they don't want, that they have religious objections to. They already have natural immunities. They're concerned about the fact that this is an experimental gene therapy and a variety of things. So we're continuing to try to find those cases where we believe we will have some success to try to get the courts to step in and try to push back against what I believe is a horrific invasion of our autonomy and personal civil liberties and civil rights. Then one other thing that I wanted to talk about is that we have now put together within NCLA what we kind of refer to as our surveillance group. And when Tracy was talking today about RFID and about this being surveillance, what we're finding is absolutely across the board, we are seeing all levels of government, and especially at that higher level, really getting involved in surveilling every aspect of our lives. And that's what RFID is all about. RFID is about controlling you, about controlling your business, and about dictating how you're going to run your operation. And if you don't do what they say, they're going to put you out of business. And that's why this is worth fighting. So one of the other areas where we've been fighting, and it may seem like it's relatively insignificant, but it's very important because it's how our government is tracking us, and that is we're suing over license plate readers. So down in Florida, there are communities that they can track you everywhere you go, and they maintain that information for years. So they're tracking your license plate. They can tell you when you were at a particular intersection, at what time of day, how many people were in your vehicle. I mean, it is really amazing the kind of information that they're gathering. And what we keep asking is, what is it you're trying to solve? What is it that requires this level of surveillance of citizens? We believe it violates the Fourth Amendment. We believe it violates the First Amendment. We believe that it violates the 14th Amendment, and so we have filed several lawsuits against these Florida communities to stop them from actually taking and maintaining that kind of information. And then the other area that Tracy again was talking about was vaccine passports. And I think we're getting very close to where we're going to be suing the state of New York, which is the first state that actually really rolled out with that idea. But we are creating a stratified society, and there are going to be those who are vaccinated and those who are not, and they have every intention of treating those two groups differently, not based upon science or anything else, but the fact that they can. And we are extremely worried about the idea of the vaccine passport concept. This is where the government is going to have all of your information. They're going to be able to do whatever they choose to do with it. And I think that it is imperative that we fight back against this. And all of us as citizens, we need to be getting a hold of our legislators, our congressmen and women, our governors, and we need to be flat out saying, no, absolutely not. We will riot if you are going to go down that road of tracking us and determining where we can go based upon vaccine status that is none of your damn business. There's just one last thing that I want to talk to you about today because it needs to be on your radar, and I know that other people are going to give you more information, but I want to tell you two stories about the idea of the 30 by 30 disaster that Joe Biden is trying to ram down our throats. That is that he is seeking to preserve whatever that word means. Nobody knows. They won't define it. They're trying to preserve or conserve 30% of our surface estate and waters by the year 2030, and then they want to start implementing the 50 by 50 program, which you can figure out what that one is as well. 50% by 50-50. Right now, the federal government controls 685 million acres of land in the United States, and that's enough. They don't need any more. They're bad at what they manage right now. It is utterly and completely absurd to consider the idea that the federal government, and especially in a state like Wyoming, where 50% of our surface estate is already owned by the federal government, that they are, through other mechanisms and by creating more national parks and national monuments and attempting to take more national forest lands and BLM lands, it is absurd to think that these agencies who are responsible for the catastrophic forest fires we've been seeing throughout the interior West for the last 5 years, that they are going to be taking control of and authority over even more lands. They want to more than double. That 685 million is 12%. They want to more than double their control over land in the United States. Right now, well, actually, my data is a little bit old, but within I think maybe 3 or 4 years ago, both the National Park Service and the National Forest Service had an over $11 billion backlog in terms of maintenance. So that is why you're seeing our forests go up in smoke, why you're seeing them burn down our communities, displacing people, and creating the problems that they are. But the stories I'm going to tell you come from 2 other countries, and this is where we're headed if we don't stop this. And that is that I was recently, in the early 1990s, I was involved in a lawsuit against Michigan State University that had a Sudanese aspect to it. I was working for a professor who was a veterinarian who the university had done some really horrible things to, and so I sued him. And he had been working in Sudan on trying to find a cure for river blindness. And the reason that's important is because I learned a lot about Sudan back then, because I had to, and I really didn't know a lot about it. And it's a horrible place to live. And one of the reasons it's a horrible place to live is it's been in the throes of a variety of civil wars for decade upon decade upon decade, and all of the leaders are completely and totally corrupt. But at the time that I was working on it, about over 90% of the food that comes into Sudan is imported because they took all of their farmers and ranchers off the land. They urbanized them and put them in refugee camps, and that's what they used the Civil War to do. They urbanized all their people, put them in refugee camps. They're incapable of growing their own food. They import over 90% of their food, and whenever those leaders want to control the masses, they starve them. They killed them. And that's how they keep control. And that's where the 30 by 30 program is headed. If you don't like being energy dependent, you're not going to like being food dependent. And that's where the 30 by 30 program is going. We need to stop looking at this as preserving the environment. We need to stop talking about protecting water and natural resources. That isn't what it's about. It's about control. It's about control of you. In Canada, I just read an article. The headline was, the second largest country in the world is running out of land. And I thought, that's a really weird headline, so I read it. And in Canada, their socioeconomic situation has dramatically changed. There is not enough land and not enough property and not enough housing. The fastest way, or one of the most important ways we've moved into the middle class and we have the prosperity that we do, is because we have affordable housing. And so when you get married at 25 or 28 or 30 years old and you start having a family, you can buy a condominium, you can buy a house, you can buy maybe a small farm, depending on what you're doing. But that's why we are the wealthiest, most prosperous country in the history of the world, is home ownership. And in Canada, they don't have that anymore. People are continuing to live in apartments even after they've started their families. What does that mean? They're having fewer kids. What does that mean? Their population is declining. What does that mean? They're becoming more and more dependent on the government. But what I also read in that article is that 89% of the surface estate in Canada is owned by the government. They're not running out of land. They have too many stupid people running their country. That is what the 30 by 30 program is about. It's about starvation, and it is about control. And we now are looking at an administration that in 7 months has wreaked such havoc on our country, on our freedoms, on our liberties. We absolutely cannot give any quarter. We cannot give one more inch in terms of giving up our entitlements, our rights to protect ourselves, our rights to protect our own private property. And so whatever you do, there are a few things that are absolutely critical for you to continue fighting, and I know you will continue fighting, and it's why I'm so glad that I'm associated with this organization. You have to continue to fight the surveillance. You have to continue to fight to protect the right for your kids and grandkids and great-grandkids to continue in the ranching industry, and you have to fight this land grab. And we'll be there with you. So thank you.